Coming up Sunday on The Attorneys, mass torts and class actions. Tyler Vail of the firm Hollis, Wright, going to lead our conversation. These two terms that we know a lot about. This Sunday night, the opportunity to kind of figure out exactly what they mean, huh?
Yeah, absolutely. I mean, they're two terms I'm sure a lot of folks just throw around and maybe don't really understand the differences or the advantages and disadvantages of each one, you know? Right. I enjoy this area of the law. It's a majority of my practice. This is what I do day in and day out.
Right.
We're going to have a terrific guest here. His name is Bill Bross. He is literally everywhere at one time. He's got offices in California, New York, D.C., right, Atlanta, and right here in Birmingham. Terrific guy. It's going to be good for everybody. I suggest they watch.
The show again, The Attorneys, Sunday night, right after Alabama's 13 News at 10. Would love to have you be a part of the conversation. Ways you can call, text, email, join the conversation. We'll see you on Sunday night.
Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The Attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into The Attorneys. We appreciate you spending your Sunday evening with us. For the next half hour, the program's pretty simple. The way this works is at the bottom of the screen throughout the program, you'll see ways where you can call, text, and email. That's so you can join our conversation, because that's the way we like to do it. We have a panel of experts to take your questions and answer them, so join the conversation. Leading the conversation is Tyler Vail of the firm Hollis Wright. Good to see you, sir.
Thank you, David.
Nice
to be here.
It's going to be an interesting conversation tonight, isn't it?
Yeah, I think so.
Yeah,
I mean, I love this topic. I spend the majority of my time practicing law, dealing with class actions and mass tort cases. So to me, I enjoy this topic. You know. But as our expert tonight, I have Bill Bross with the law firm of Henniger, Garrison, Davis, right here in Birmingham. Bill is an absolute, talk about a go-to guy. You know, when you have an issue, when I have an issue with a mass tort case and I'm not real sure, I need some answers and I need them quick. I mean, Bill, regardless of time of day, he's always been there for me. So a good friend, but a better lawyer. And so he is actually one of the top folks here in the state of Alabama that does mass torts. And so it's a pleasure to have him on. Thank you, Bill, for coming on. And we look forward to educating the viewers tonight and then kind of seeing where this thing goes.
Bill, again, welcome. Thanks for the time. And kind of give us an overview of your firm, your practice, and your level of expertise, specifically relative to class actions, mass torts, in our conversation tonight.
Well, thanks for having me. Basically, that's what I do, is mass torts and class actions. With my background, before I became an attorney, I had a background in the medical field, so it all just sort of interrelates. But my niche is doing basically pharmaceutical, medical device litigation, other class actions that come up from day to day.
And he's been doing it for a long time as well. I mean, like I said, their firm, their position, they have, I guess I'd call it a headquarters. Their main firm's here in Alabama, but they also have offices, I mean, as far from California all the way to New York, D.C., Atlanta, everywhere in between. And so, he gets around a lot more than a lot of folks here. He's seen a lot. Yeah. He knows a lot. Like I said, I'm glad he's here with us tonight.
Help us. These are terms, you all use them regularly, and they're a part of your everyday vernacular, maybe. But when the public hears about them, it's usually whenever it's on the news and there's a big time case. So help us understand the terminology. First of all, let's just start with class action. What can you put that in layman's terms? What is class action?
Well, it's basically a case where an individual or a group of individuals brings a lawsuit on behalf of everybody. Okay, against a defendant or a group of defendants, alleging that something has happened that's injured them. And it could be a health injury, it could be a financial loss or something like that. And the key is, though, they all have very similar injuries, and it's easy to put them in the same box, let's say.
Yeah, a good example, though, is right now, I know a lot of folks on news, the GM, all the recalls dealing with either the defective, in the steering column, the key, the ignition switch, whether some kind of braking issue, steering issue. So, automotive is probably one of the hotter areas for class actions, at least at this, day and time.
Right. So class action really, it's more of an issue that may affect a larger number of people than just something just with one individual.
It could be. Some class actions cover large numbers of people, millions of people. Some of them are much smaller. The ignition recalls and things like that, like Tyler mentioned, are a pretty good number. Most of them fit that mold.
Is there a minimum number of people to have a class action lawsuit?
No, I'd say no, not really. I mean, there's some case law out there, and it's a little bit dated, but I've seen class actions with as few as 40 individuals in it. And like Bill said, I've seen class actions with 15 million people in it.
Oh,
so yeah, so there's really no bright line test, but it's got to be more than just a couple dozen.
From a complexity standpoint, are class action lawsuits any more difficult for you all on the legal side?
Well, they can be.
Right.
You're usually dealing with number one, with a huge, often international company with vast resources.
Right.
It makes it, if you're one individual, one plaintiff, there's no way you could really litigate a case like that. That's why it takes a case like that will let you just bring in so many people that would have a chance against a large corporation.
Right. It's a good way to kind of level the playing field when you have like Bill said, a huge defendant, and most time these cases always involve some huge international defendant. If you just have one little guy here who's upset about a contract term or a fee he was charged on a cell phone, it's $2 a month. He's never going to be able to find a lawyer to take that case to get his $2 back. It's just not going to happen. As much as we like to help people, we still have to be able to at least make some bills and pay our employees and pay our rent. And so those kind of cases just would never work out except for this idea of a class action lawsuit. What it does, it allows that one individual with that $2 fee to sue on behalf of 25 million people with that $2 fee. So now, you're looking at a $50 million case. It really gets the attention of not only lawyers to help you, but also of defendants, and the big defendant sitting overseas somewhere. And so it really levels the playing field, because without that, someone with a $2 claim, this court system is just not set up to help someone like that.
And kind of from a history standpoint, there have been some notable class action lawsuits. My father-in-law was involved in an asbestos class action suit a number of years ago, but from a kind of a historicity standpoint, there have been some notable class action lawsuits that have changed a number of the way things are done, correct?
Oh,
there have, especially in a lot in the financial industries, the insurance industry, with unfair practices that have gone on. BP oil. I think everybody's aware of the BP oil and how that affected industries, individuals, and people's health.
But you look at a lot of the Americans with Disabilities Act, something that comes into play every day for millions of people. Some of the examples that Bill had said, the big mortgage mess, the meltdown supposedly, over the last 5 years ago. All those things, class actions filed on behalf of those individuals led to the reforms and to the change that, it really has had a good effect on them.
Are there different types of class action lawsuits?
There are, if you follow the rules. There's a few types. There's one, an injunctive type, where basically if a class is certified and it's put in place, it stops somebody from doing something. There are class actions where you either opt in or opt out of the class. Mainly what we deal with, if we see it in the healthcare area, is a lot of opt-outs. There may be some type of a class that may benefit a large number, but there may be reasons that wouldn't benefit everybody.
Right, and what we mean by opt-out is that you're in this case, whether you signed up with a lawyer, whether you signed a contract, or whether you filed a lawsuit, you didn't have to do any of that. You're actually included because of the description of the lawsuit, and you filed as a class, and basically someone has sued on your behalf and everyone else just like you to get some benefit.
Right.
And so you're in that class already. You'll get a notice in the mail that usually talks about it. I'm sure everyone's got at least one or two in the past. And it may say, hey, if you don't want to be part of this, you have the right to opt out, send this form back, or you can opt in, or you can do nothing, and you'll remain part of the class. So, yeah, those are certainly the three most basic types that you'll be confronted with.
Okay. Let's take our first break. When we come back, the advantages, kind of the pros and cons, look at class actions from that standpoint. Question on the advantages of class actions and whether it's always the best solution. We'll take that question to our panel of experts. Would love to have you be a part of the conversation. Here's how you can call, text, and email. Also, a reminder, you can find the firm of Hollis Wright on Facebook. Just search that term. And on Twitter, they are Hollis_Wright to find them there on Twitter. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright, and thanks for watching the attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. Or simply contact us by going to alabamas13.com and click on the attorney's link. Now, we know your time is valuable, so thank you for spending it with us and for watching the attorneys right here on Alabama's 13.
Welcome back into the attorney's class actions and mass torts, the topic of conversation tonight. We'd love to have you be a part of our conversation. Call, text, email. That information displayed on the bottom of your screen throughout the evening. When we went to break talking about class actions, what are the advantages of class action?
Yeah, I think we touched on a little bit earlier about, most class actions deal with small monetary damages. Very rarely do they deal with a physical injury or what I'd consider a major injury that would lead to significant compensation. So a lot of times we're dealing with very small economic damage claims of less than $100 a person, which is tough to find lawyers to handle. And so the advantage is everyone can group together, kind of pool their claims and have a more sizable claim to kind of like say either get the defendant's attention or also find some lawyers to help represent you. That's probably the biggest advantage. One of the disadvantages is, you have individuals who you do not know, and they may be from, California or New York, and they may have filed this case and are trying to include you in their case, and you really have no say. You can't really control litigation. You're part of it. You're just going to sit there and wait to the end, and you're stuck with the result. So a lot of folks like the idea of, hey, I want to control my own lawsuit. I want some say in what's going on. I want my name on the complaint that's filed in the courthouse. I want them to know about me. So that's probably the biggest disadvantage. And also, I think the stereotype with class actions is a lot of people don't want to be part of them because they've heard stories about, all it does is lawyers just get all the money and I get a coupon for $5 to, some restaurant or some credit card company. And so it has such a bad stigma these days about class actions just aren't worth the trouble. And that's one of the disadvantages. It's hard to get people to overcome what they already feel, but again, that's really not the case. There's some great litigation out there, some good class actions. At the end of the day, we're just trying to help folks.
All right, so that's class action. So let's move to mass torts. What are mass torts and how are they different from class action?
Yeah, mass torts, there are a lot of similarities, first of all, but they are different. They are individualized damages. It's things that you can't quantify or put in a box like you can with a class action, let's say. It's not to say at the end of the day you won't have a large group of them. You do. That's what we do on a daily basis. We might see within one particular pharmaceutical case, hundreds of people, or we might see 10 people, or we might see thousands of people. So they can all be grouped together. A lot of times with the mass tort cases, they are grouped together in litigation for purposes of being more efficient. We have clients all over. You're in Alabama. How can you help us? We're in various other states. Well, the cases are going to be centralized usually before one judge, and there are great benefits to that to get things moving along. That's what I guess makes a mass tort unique.
Yeah, it does. And again, the big part of it, it's individualized. You're going to control a lot of your litigation, and when you get to the end, you actually have some say as, yes, I'll accept this settlement, or no, I don't want this settlement, I want to keep fighting my case. And so you just have a lot more autonomy, I guess, in these type cases. But they are centralized, there's usually going to be grouped together, and that's to get your case moving, because what you don't want is 30,000 cases filed in totally different courts, all over the country, and everyone's given a different ruling on this, motion and this motion, and you got conflicting laws, conflicting orders, and everybody, it would gum up the system so bad, you'd be stuck in litigation for the rest of your life. This way, the consolidation helps to get these things moving, and usually I'd say within 5 to 6 years, which may sound like a long time, but when you're dealing with this many cases, 5 to 6 years being the top end of how long it would take, as opposed to 25 years if everyone was doing it separately.
Now I've got a question here about an MDL. What is an MDL?
That's a multi-district litigation.
Okay.
That's what Tyler was mentioning. I mentioned it's basically where cases from all over, if they're based on the similar harm done, for example, by a pharmaceutical, they're all grouped before one judge.
Okay.
There is a committee of judges that meets every few months once a motion is filed or once people ask for an MDL for something like this. And then they usually pick from experienced judges that have handled these things, and they'll be before one judge to move the litigation along.
That's right.
And the advantages of that?
Oh, huge advantage of that. Now, like I said, you get one judge, make one ruling that applies to every single person. And it's like he'll put a deadline on, you got 30 days to do all this stuff, everybody's got to do it within 30 days. I mean, they really get control of it. Like Bill said, it's important they get with an experienced judge in a convenient location where lots of, everyone can get to easily in and out of, and you can get a judge that's moving this case along. And we've had cases that move, from start to finish within a 18-month period. We're talking 15,000 cases at one time. That's insane.
Wow.
But it happens.
Yeah.
So very important.
Ever a jury in an MDL?
There are.
Absolutely, yeah.
I'm sorry. No. There are what's called bellwether or hand-picked cases from the earliest filed cases. Usually the plaintiff's side will pick cases that they feel like are best for the litigation. The defendants, of course, will do the same. The judge then will come up with a process to select those cases. I've seen MDLs where they've had to try cases, to help get everybody to the negotiating table, let's say. I've seen MDLs where they've never had to try cases.
Right.
So, just because there's an MDL does not mean there won't be a trial.
No, that's exactly right. And that's a very important part of the MDL, is to try to establish value to all these cases. Because we have 100,000 people that may be claiming all the similar ailments from the same defective device, defective medicine, or other thing. How do you establish a value for all these people? Well, it's tough. Well, so what you do is you try to take 2 or 3 representatives of the type of injuries these folks have and try the case and see what a jury says. And once a jury has spoken and gives a verdict, then that helps people decide, hey, this type of case may be worth $150,000. This type of cancer over here may be worth $400,000. So the trials are very important, and there's not many firms that actually try cases in MDLs, but Bill's firm actually has tried case in MDLs. Okay. So we might want to come back, to close start of our next segment here, and let Bill talk a little bit about that.
Yeah, some of those bellwether case examples that you all have, we'll do that. We'll take this, our second break of the evening. Still another full segment to go, so plenty of time for you to get your questions into us. Call, text, email, join the conversation. We're going to take a quick break. One final segment of The Attorneys coming right up. Stay with us.
I'm Josh Wright with the law firm of Hollis, Wright. Now, we often hear the phrase burden of proof when it comes to civil or criminal lawsuits. It's the level of proof that a plaintiff must meet to win their case. But these burdens change whether you're in a civil or a criminal court. So in this week's Legal 4-in-1, we're answering the question, who holds the burden of proof and what is the burden in the case? Let's start with civil cases. Civil cases are brought by a plaintiff who claims they have been injured by some way by a defendant. Because there is no chance of jail time, since the injury does not amount to a crime, the burden of proof is not as difficult as in criminal cases. The level of proof here is called preponderance of the evidence. In general terms, that means the plaintiff must prove that it is more likely true than not true that the defendant is responsible for the plaintiff's injury. You've seen the scales of justice before. Both parties have to fill those scales up with evidence to support their position. If the plaintiff can fill his scale up with just a bit more evidence than the defendant, the plaintiff wins the civil case and is entitled to a verdict. Now, the stakes are much higher in a criminal case than that of a civil case. That's because a criminal defendant could lose his freedom, or even his life if he's found guilty. So who holds the burden of proof in a criminal case? Well, the state does, because the defendant is being accused of breaking state law. The state has to prove beyond a reasonable doubt that the defendant is guilty. It's the heaviest burden in the justice system. The evidence has to be so convincing that the jury believes beyond any reasonable dispute the defendant is guilty. Probably guilty just isn't enough in these cases. The law requires the jury to find the defendant not guilty if there is any doubt at all. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys right here on Alabama's 13.
Welcome back into The Attorneys. This is our final segment, so if you have a question you would like to be answered, there are live attorneys standing by right now. Call, text, email, join the conversation. Whenever we went to break, talking about bellwether mass tort cases, and Bill, your firm has some experience there.
Yeah, we have. We were fortunate, I guess, to get to try a Vioxx trial some years ago here, actually in Jefferson County. It was for you that aren't familiar with Vioxx, it was a anti-inflammatory, very, very common drug that caused heart problems. So it was very instrumental as one of the trials. There was a total of 13 trials in that litigation. Ours was the last trial before actually there was a global settlement in the litigation. We hope that some of what we did led to that. But we've also been involved on the periphery on other trials. In Levaquin, in diet drugs. There's been a lot of cases over the years. So, there's a lot more to trying a case than just getting in the courtroom and actually, doing the trial. There's a whole lot of background work that goes on, especially when you're dealing with these large cases against these very large corporations.
And anytime you're dealing with medicine and you got to deal with causation, it becomes so hard. You're getting experts involved that experts I didn't know fields existed for. We're having to find experts to come in and talk about, how these drugs inhibit different enzymes inside the body, and how that inhibiting that one enzyme can lead to a heart attack or some kind of blockage or strokes or things like that. And so, yeah, the amount of difficulty involved is sometimes overlooked and just thought of, hey, we'll just go try this case in front of a jury. But to actually get there, 98% of the work is done before trial. That's the easy part in getting there.
The firm fact coming in from break was the amount of money that drug companies have spent on advertising. I think it's
like a 2-to-1 ratio on advertising versus research, and that's just kind of the world we live in. I mean, there's anything wrong with that, and it's certainly in the show to talk about how bad drug companies are, medical device companies, because Bill will agree, and I know you will agree. I mean, how many millions of Americans have such great benefits because of the medicine they take every single day, who wouldn't be able to do the things they could do without the medicine they take, and so we certainly don't want to, go down that road at all. But also, when you have an industry where they're spending that type of money on advertising, you really got to pay attention to what they're doing, because it's a very competitive industry. Drugs are only on the market, protected for a certain number of years, and if they don't get every dollar they can during those years, they could get in trouble, and so whenever someone's spending that kind of money on marketing and really trying to push their product so hard, you just got to make sure they're not cutting corners, make sure they're doing it right, and make sure they've done the proper studies and made people aware of the possible side effects before they, put something in someone's body. So it's important.
I think you're right to echo on that. What we see when we do a lot of this preparation in all these different MDL cases or pharmaceutical cases is the amount of time and money and all that's devoted to marketing, like you said, when compared to the research and human studies they've done, it is a fraction of that.
And so it is what it is.
It is. But being able to spend that amount of money, I would think taking those folks to trial could also be quite expensive as well.
It is, and then, like I said, to go back a little bit to Bill's experience, I know on the Vioxx case, that was one of those cases that Man, that's a tough case. That was an extremely tough case. We're talking about usually, folks over 50 years old who have inflammatory problems, maybe a little bit early onset arthritis, things of that nature, and they're taking it almost like you would a Vioxx or an Aleve, something like that, but it was causing heart attacks. Well, how many other folks are having heart attacks at 50 plus years old who are not taking this medicine?
Right.
I mean, and so to wind and maneuver down that road and that causation is just, like I said, it's very tough, and the case they tried, it was instrumental in leading to a global settlement of over $4 billion, which at the time was the largest pharmaceutical settlement, reached. So it was a great case. Certainly, they do the stuff all the time, so that's no big deal to them. But for everybody else, that's a big win. It's a big deal.
Another question that we have in here: what types of cases are typically filed as mass torts?
Usually what you see is drug or pharmaceutical cases. We mentioned one, and we'll talk about a few others in a minute. We see medical devices. I know on the news lately there's been a whole lot of discussion about the metal hips, the hip on hip. There's a lot of manufacturers out there that are involved in that. We do see a lot of environmental type cases that are filed this way. We touched on earlier the BP case, which is sort of a crossover type of a case, if you will. But yeah, there's always something new every day, or every week or something. Right. We're constantly researching to see what might be out there. We're all for good drugs and good products. You just need to follow the rules and the regulations to protect us.
Yeah, and that's true. I think the majority of the cases today that are in the MDLs are all going to be the pharmaceutical or medical device. Asbestos still has an MDL set up. It's been around for decades. It's probably going to be around for a couple more decades. It's just never going away. There's been some roofing products, housing materials, construction products that'll get MDL'd, but that's kind of a small section of what's happening.
Right. Yeah. Less than 3 minutes, but I know your firm is handling some current mass tort cases now, right?
Yes, we are. Yeah, let me touch on a few for you. We're looking at a drug called Xarelto, which is a anticoagulant drug. It's a great benefit. Unfortunately, though, it swings you the opposite way. People that are using this drug are having more serious bleeding problems than they would on the regular Coumadin or warfarin, type drugs that they used to use. Right. So we're looking at those cases where people have had serious bleeding problems. We are looking at the vaginal mesh used in women after they needed surgery for urinary problems or for organ problems, and there's been a lot of that in the news lately. Those cases are moving along. There's numerous manufacturers in that case, and there's been a number of trials in those cases too, the bellwether trials that we talked about.
Yeah, we're just about out of time, but I wanted to give both of you gentlemen opportunity just for a final thought and something to leave our viewers with relative to tonight's subject. Bill, you first.
Yeah, and again, we drugs and medical devices are needed. We just think that individuals need to be aware of what's going on, and that companies need to be sure they're following the rules and regulations when they're putting these on market.
Yeah, and I would just say to the viewers out there, a lot of folks don't know maybe a drug is causing a problem, or even what kind of device they have. Maybe they got a hip 3 or 4 years ago, but they have no idea what type it is,
Right.
And so that's something that we can easily figure out for folks. All they have to do is call us, call Bill, and that's something we can do, usually within just a matter of days, if not a couple weeks. And we can kind of help steer folks and let them know, hey, you probably have a case, you don't have a case, but never be scared or intimidated to just call a lawyer and ask questions. I mean, that's what we're here for.
Yeah. Awesome. Well, appreciate both of you all being with us. Interesting conversation tonight. Hope you enjoyed it as well. We appreciate you joining us each and every Sunday evening as we wrap things up. Just to let you know, here's how you can continue to contact the firm of Hollis, Wright. Call, text, email. Do their very best to answer every single email. So if you get in touch with them, they're good about getting back with you. We thank you so much for being with us. We'll look for you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis Wright.